martial law is not illegal. Then why do the media and judges call it unlawful? Many people think this way. If martial law is written into the Constitution, then if a president uses it, isn't it legal? That is partly true. Article 77 of the Constitution of the Republic of Korea states that the president may proclaim martial law in time of war, armed conflict, or a national emergency equivalent to such situations. In other words, the system itself clearly exists. Martial law is a constitutional power. But here lies the most important distinction: the existence of a system and the lawful exercise of that system are completely different matters. A knife is legal, but if it is used outside self-defense, it becomes illegal. Martial law is no different. The Constitution does not permit martial law at any time. It attaches clear conditions. War, armed conflict, or a national emergency equivalent to such situations. These requirements must be satisfied. So the heart of the debate is this: was the situation truly a national emergency? Was martial law truly unavoidable? Were there no other available means? Were procedures properly followed? The law always examines whether the requirements were met. In particular, martial law can restrict fundamental rights: freedom of the press, freedom of assembly, the warrant requirement, and even military involvement in civilian policing. All of these can be affected. For that reason, within a constitutional order, martial law must be a last resort. This is known as the principle of proportionality and the principle of minimal infringement. An exercise of power stronger than necessary may be judged unconstitutional. Therefore, when judges use the word unlawful, they usually do not mean that the institution of martial law itself is illegal. They mean that the particular use of it may not have satisfied constitutional requirements. When the media raise the possibility of illegality, it is for the same reason. Was it truly a national emergency? Was it merely political conflict? Was there an abuse of power? That is what is being examined. The conclusion is simple. Martial law as a system is legal, but if its requirements and procedures are not satisfied, it can be judged unconstitutional or unlawful. The Constitution grants power, but it also limits power. It gives the president strong authority, but attaches strict conditions. This is not a matter of emotion, nor is it simply political preference. It is a matter of constitutional structure and limits on power. The answer to whether martial law is legal or illegal does not depend on whether the system exists, but on whether its conditions were fulfilled. Once that distinction is understood, it becomes clear why the same act can be described as legal by some and unlawful by others. And there is another step to consider. Martial law is not merely an administrative measure. It is the activation of state power, strong enough to shake the entire constitutional order. That is why the Constitution allows it but also builds in oversight mechanisms. The National Assembly has the authority to control it and demand its lifting. The judiciary can review its constitutionality afterward. Martial law may appear to be a presidential power, but it is not unlimited. In a democracy, the greatest danger is concentrated power without functioning checks. That is why constitutional systems are designed as power plus control. In times of emergency, swift decisions may be necessary. But if power is exercised excessively under the name of emergency, the constitutional order itself may be threatened. So the legal questions remain. Were no other means available? Was ordinary law insufficient? Was military involvement truly necessary? Were restrictions on rights kept to a minimum? If the answers are insufficient, the declaration of martial law may be seen as an excessive exercise of power. Another crucial point is that the law evaluates objective conditions, not merely intent. A president may sincerely believe that action was necessary for national stability, but the law measures objective circumstances, the level of actual danger, the scope of restricted rights, the legality of procedures, and the consequences of the decision. That is why some say it is legal because it is in the Constitution, while others say it is unconstitutional because the requirements were not met. Neither statement is entirely false. They focus on different aspects. One speaks of the existence of authority. The other speaks of the lawful conditions for exercising that authority. The Constitution both grants power and restrains power. Every time the word martial law appears, society becomes sensitive, because it is not just a policy choice. It alters the nature of state authority. In essence, martial law is a lawful institution, but its exercise is not automatically lawful. The boundary between legality and illegality depends not on the existence of the system, but on whether constitutional conditions were satisfied. Now consider this framework in the context of the recent case involving former President Yoon Suk-yeol. The central issue was singular. Did the situation at that time qualify as war, armed conflict, or a national emergency equivalent thereto? Under Article 77, the government's position was that national order faced serious threat, and that ordinary legal mechanisms were insufficient. They argued that constitutional authority was exercised within legal bounds. Critics responded that political conflict and social unrest do not automatically amount to a state equivalent to war or armed conflict. If civilian law enforcement mechanisms were sufficient, military intervention through martial law could be excessive. Thus, the familiar standards reappeared: necessity, proportionality, minimal infringement, procedural legality. Was martial law the only viable option? Were fundamental rights restricted only to the minimum extent? Were legislative oversight mechanisms respected? Was the decision free from political motive? These questions shaped judicial review. The dispute was never about whether martial law exists in the Constitution. It was about whether the constitutional threshold had been met. On February 19, former President Yoon was sentenced to life imprisonment. Yet sentencing does not automatically conclude the legal process. He has until next Thursday to petition for a retrial. This moment illustrates two principles operating simultaneously. First, no one, not even a former president, stands above the Constitution. Second, every defendant is entitled to due process and legal remedies. A retrial is not merely symbolic protest. It requires substantial procedural error, new evidence, or serious misapplication of law. If a retrial is requested, the same constitutional questions will be revisited. Were the conditions for martial law satisfied? Was there an abuse of authority? Were procedures properly followed? Did the court err in applying constitutional standards? If the retrial is denied and the judgment becomes final, the legal debate will close, and the case will pass from politics into history. This outcome is not only about one individual's fate. It defines the outer boundary of emergency power, clarifies the limits of presidential authority, and tests the independence of the judiciary. The Constitution teaches two enduring lessons. Power is delegated, and delegated power carries responsibility. At the same time, no person may be punished without due process. Next Thursday is not merely a date on the calendar. It represents another moment when emergency power and the rule of law intersect. Martial law was constitutionally permitted as an institution. Whether its use crossed constitutional limits is determined through judicial process. Power may pass, but constitutional records remain.